I want you to picture a specific place and time with me.
Okay.
It's June 19th, 1990. We're in Scarborough, Ontario, which is, the eastern district of Toronto.
Right.
It's Tuesday. And the weather is that specific kind of humid warmth you get in southern Ontario right as spring is turning into summer.
Hmm.
We're looking at the University of Toronto's Scarborough campus. It's a very distinct piece of architecture, this massive concrete structure that's kind of set down into a valley.
Brutalist architecture.
Exactly. And it's surrounded by this really dense parkland, specifically Colonel Danforth Park. It's normally a place of, high energy, students everywhere, but classes have just finished up for the year.
So it's quiet.
The campus is much quieter. And walking through this scene is a young man named Robert Baltovich.
To set the biographical context here,
Yep.
Baltovich is 24 years old at this moment. He has just graduated. Convocation was only 11 days prior, on June 8th.
So this should be the best time of his life.
It should be. He holds a Bachelor of Science degree, having majored in psychology and history.
Right. And those two majors, psychology and history, it's almost ironic given what is about to happen to him. His own personal history is about to be rewritten by the state, and his psychology is going to be tested in ways that are, well, they're hard to even imagine.
He's dating a fellow student at the time, 22-year-old Elizabeth Bain.
And by all accounts, they're just a normal university couple. They met in a psychology class, which is fitting. They study together. They spend time with their families. Just normal.
Very normal.
On this particular Tuesday, Elizabeth tells her mother she's driving to the campus. Just a quick errand, she says. She's going to check the tennis schedule.
The definition of a mundane task.
Completely mundane. She gets in her car, she drives off, and she is never seen again.
This is the inciting incident, but we really need to be precise about the timeline of the disappearance because it dictates the entire investigation that follows. She leaves her home late in the afternoon. When she doesn't return for dinner and then doesn't return overnight, the alarm bells start ringing pretty quickly.
So this isn't a case where a family waits for 48 hours to file a report.
No, not at all. The concern is immediate, the police are notified, and the search begins.
And for 3 days, there's nothing. Just silence, which must have been agonizing for her family. Then, on Friday, June 22, her car is found.
And where it's found is significant. It's parked on Moorish Road, which is quite close to the campus, right near the edge of that dense parkland you mentioned.
And the discovery of this car, it instantly shifts everything. This isn't just a missing person case anymore. It's a potential homicide investigation.
Instantly. Because of what they find inside.
In the back seat, there is a large bloodstain.
The forensic analysis of the vehicle becomes the first critical pivot point of this whole story. The blood was typed, and it was matched to Elizabeth Bain.
And the amount of blood?
Yeah.
It wasn't a small amount.
No. The volume of blood indicated a significant injury, one that would almost certainly be life-threatening without immediate medical attention.
So the car is there, her blood is there.
But Elizabeth Bain is not.
And this brings us to the central complication of this entire analysis. There is no body. We are going to spend this time unpacking a legal and investigative saga that spans decades, but it all just orbits around that one void.
That fact?
Nobody was found in the car. Nobody was found in the ravine. To this day, Elizabeth Bain's remains have never been located.
Prosecuting a homicide without a body is one of the most difficult challenges in criminal law. It creates a vacuum.
A vacuum of evidence.
Precisely. Without a body, you cannot definitively determine the cause of death. You can't prove the time of death with pathology. You can't collect trace evidence from the victim's body that might point to an attacker. Things like skin cells under fingernails or biological fluids.
So what does the Crown, the prosecution, actually have to prove in a case like this?
They have to prove two fundamental things beyond a reasonable doubt. First, that the person is actually dead and not just missing. And second, that the accused is the person who caused that death.
So the police have a car, a blood stain, and a boyfriend. And very, very quickly, the investigation creates a tunnel. They start looking at Robert Baltovich.
Well, statistically, the partner is always the first person investigators look at.
Right. But they didn't just look at him, they locked on.
The investigative theory that developed was highly specific. And it is so important to understand that this theory wasn't just a hunch. It became the structural backbone of the entire prosecution.
Okay, so what was it?
The police believed that Baltovich killed Elizabeth on that Tuesday, June 19, likely in or near her car. They believed he then took her body and hid it in the dense underbrush of Colonel Danforth Park.
That's the valley area surrounding the campus, a huge wooded ravine.
Correct, but the theory gets more complex. The police didn't think he moved the car immediately.
So he just left it there, with her body nearby.
That was their theory. They theorized that he left the body in the car, went about his life for 3 full days, presumably to establish some kind of alibi or just to regain his composure, and then he returned to the scene. On Friday, June 22, the theory was that he went back, retrieved her body from the park, put it into the car, and then drove it to a second unknown location to dispose of it permanently.
And only then, after all that, did he abandon the car on Morris Road where it was found.
Exactly.
This is what you call the 3-day gap theory.
Yes.
And it's crucial because it relies on this idea that he was so cool-headed, so calculated, that he could kill her, leave her body in a public park, and then just wait, and then come back days later to clean everything up.
The level of calculation and risk-taking it suggests is quite extreme. You are returning to the scene of the crime 3 days later when police searches could already be active in that very area.
It also requires a very specific forensic narrative, right?
It does. If you put a body that has been deceased for 3 days into the back of a car, particularly in the June heat, the forensic evidence in that vehicle, things like decomposition fluids, insect activity, different blood transfer patterns, it would all need to match that timeline.
And we're going to get into whether the evidence actually supported that later on. But for now, this was the police thesis. This was their story.
This was the story.
So, based on this theory, on November 19th, 1990, that's 5 months to the day after she vanishes, Robert Baltovich is arrested. He's charged with first-degree murder.
He's 25 years old now. He's sitting in an interrogation room, and he's being told that he planned and deliberately killed the woman he loved.
The first-degree charge is key.
It implies premeditation and deliberation. The Crown was asserting that this wasn't an accident or a crime of passion in the heat of the moment. They were saying it was a planned event.
Which raises the stakes immediately. A conviction means a mandatory life sentence with no chance of parole for 25 years.
The highest penalty in Canadian law.
Okay, so let's move forward to the courtroom. The trial begins in 1992. And we really need to understand the atmosphere in Scarborough and Toronto at this specific time. If you were living there in the early 90s, the vibe was shifting. There was a current of fear running through the community.
The context of the Scarborough rapist is absolutely essential here. Between the late 1980s and the early 1990s, there was a serial predator operating in Scarborough. He was attacking women, often dragging them into areas very similar to where Bain's car was found.
A monster in the shadows.
But here is the key point for you to grasp. In 1992, at the time of the trial, the identity of this predator was completely unknown. He was a phantom. The police had a profile, they had DNA samples from his crimes, but they did not have a name.
And that makes the defense's job incredibly difficult. Baltovich's lawyers, William Gatward and Michael Engel, they argue that Robert didn't do it. Their main argument was that the Scarborough rapist was a likely culprit.
But because they couldn't point to a specific person in the prisoner's dock and say it was him, it sounded speculative. It sounded like they were blaming a ghost.
The boogeyman.
It's the difference between a specific alternative suspect and a theoretical one. If the defense can say, John Smith did this, and here is proof he was in the area, that is powerful for a jury. But saying an unknown serial rapist might have done this requires the jury to take a leap of faith.
So the prosecution could just bat that away.
Easily. The prosecution could counter by saying the Scarborough rapist attacks were sexual assaults, whereas this was a disappearance and a likely murder. They could try to distinguish the modus operandi. Without a known suspect, the defense's alternative theory lacked real weight.
Now, the trial judge was a man named Justice John O'Driscoll. And the way a judge handles a trial is, well, it's usually invisible to the public unless something goes terribly wrong.
In a jury trial, the judge is meant to be the neutral arbiter. They explain the law, they decide what evidence the jury gets to hear, but they are not supposed to pick a side.
But they have influence.
A judge's influence on a jury can be subtle but profound. It can happen through their tone of voice, the way they summarize the evidence for the jury at the end of the trial, or even how they interact with the defense counsel versus the prosecution. If a judge appears skeptical of the defense's case, the jury will pick up on that cue.
And we'll come back to Justice O'Driscoll. So the jury goes out, they deliberate, and on March 31st, 1992, they come back with a verdict.
They find Robert Baltovich guilty.
But not of first-degree murder.
No, they convict him of second-degree murder.
What's the significance of that distinction? What does that tell us?
Second-degree murder generally implies an intentional killing that was not premeditated or planned. It suggests the jury may not have bought the full, planned, and deliberate narrative from the prosecution, but they were still convinced beyond a reasonable doubt that he caused her death.
But the sentence is still life in prison.
It is. He's given a parole ineligibility period, which means he cannot even apply for release for a set number of years. For a young man with a university degree and no prior criminal record, this is a complete descent into hell. He enters the federal penitentiary system.
And he maintains his innocence the entire time.
Consistently from day one.
We often gloss over the time served part of these stories.
Mm-hmm.
But it's important to analyze what actually happens to someone who is a denier in prison.
It's a critical point. The correctional system is built on the concept of rehabilitation, and that process almost always starts with an admission of guilt.
Right, you have to admit you have a problem to fix it.
Exactly. So if you are a convicted murderer who steadfastly maintains your innocence, you are often viewed by the system as being in denial, or worse, lacking remorse.
So the system works against you.
It can. You are frequently deemed ineligible for certain rehabilitative programs or transfers to lower security institutions because you refuse to address your criminogenic factors. In this case, the murder you say you didn't commit.
So you're in a catch-22. To get out sooner, or just to get better treatment inside, you have to lie and say you did it.
But if you hold on to the truth that you're innocent, you often end up serving harder time.
Baltovich spends 8 years in this limbo. 8 years. That's his entire late 20s and early 30s gone.
And while he was incarcerated, the legal landscape outside of the prison walls was changing. An organization called the Association in Defense of the Wrongly Convicted, or AWIC.
They're called Innocence Canada now.
Yes. They began reviewing his case. And this organization only takes on cases where they believe a factual miscarriage of justice has likely occurred. James Lockyer, who is a preeminent lawyer in this very specific field, took the lead on the file.
The involvement of someone like James Lockyer is usually a pretty strong signal that the system may have made a serious mistake.
A very strong signal.
So his team starts digging. They're looking at the trial transcripts, the evidence, the police work, and they start finding problems, serious problems. And on March 31st, 2000, exactly 8 years to the day after his conviction, Robert Baltovich is released on bail, pending his appeal.
Granting bail for a convicted murderer while they wait for an appeal is exceptionally rare.
Why is that?
Because the presumption of innocence is gone after a conviction. To get bail at that stage, the defense essentially has to show two things: that the appeal has a very strong probability of success, and that the continued detention of the individual would be unjust.
So the fact that the court granted his release...
It was a massive signal that the original conviction was on very shaky ground.
But he's not free yet. He's just out. He's living in this strange limbo, waiting for the system to churn. He has to wait another 4 years for the appeal to actually be heard and decided.
4 years on bail.
Finally, in 2004, the Ontario Court of Appeal releases its decision. And they don't just overturn the conviction, they eviscerate the original trial.
The ruling was remarkably harsh, particularly regarding the conduct of the trial judge, Justice O'Driscoll.
What did they say?
The Court of Appeal found that the judge's charge to the jury, his final instructions on the law and evidence, was unfair and unbalanced. They essentially said that the judge had acted in a way that prejudiced the defense, creating an unfair trial. So they set aside the conviction.
But, and this is a huge but that people need to understand, they didn't acquit him. They ordered a new trial.
That is the standard remedy in these situations. If the first trial was ruled to be unfair, the law says do it again, and this time do it properly. It doesn't automatically mean the accused is innocent, just that the process that convicted him was critically flawed.
So after all this time, Baltovich was right back at square one, facing a new charge of second-degree murder.
Precisely. On July 15, 2005, the Ministry of the Attorney General officially announced they would proceed with a new trial. He remained free on bail, and he was actually working as a librarian for the government of Ontario during this period.
Just trying to live a life while this massive storm cloud is still hanging over him. So now we are in the mid-2000s, and the entire landscape of this case has shifted dramatically because of two major factors that weren't in play back in 1992.
Right.
The first is that ghost I mentioned earlier, the Scarborough rapist.
The Phantom.
He's not a phantom anymore. By 2004, everyone in Canada knew his name. Paul Bernardo.
Paul Bernardo had been arrested in 1993 for the horrific murders of Kristen French and Leslie Mahaffey. It was subsequently revealed through DNA evidence that he was indeed the Scarborough rapist.
So this completely changes the defense's argument. It goes from a theoretical somebody else did it to a very specific he could have done it.
It provided a viable, concrete alternative narrative. The defense could now point to Bernardo.
And there were circumstantial links, weren't there?
There were. Bernardo was known to be operating in that specific area of Scarborough. There were reports of him stalking women near the university campus, the modus operandi attacking women, the element of sexual violence. It suddenly looked a lot more relevant to the Bain case than it had when the attacker was an unknown entity.
The defense's job isn't to prove Bernardo did it, right?
Correct. They only have to show that it was a reasonable possibility. If it's reasonable to think that Paul Bernardo abducted and killed Elizabeth Bain, then you cannot be sure beyond a reasonable doubt that Robert Baltovich did it.
Now, for the record, when Bernardo was asked, he denied any involvement in Bain's disappearance.
He did. But his denial carries very little weight, obviously.
So that's the first huge change. The second factor is more technical, but it's just as devastating to the prosecution's case. It involves hypnosis.
Yes.
Back in 1990, during the initial investigation, the police had used hypnosis on some of the witnesses.
In the 1980s and early 90s, forensic hypnosis was a surprisingly popular investigative tool.
It sounds like something out of a movie. Look into my eyes. You're getting very sleepy. Now tell me the license plate number.
That's essentially the pop culture version of it. The theory was that a witness who saw something traumatic might repress the memory or just not consciously recall key details, like a face or a piece of clothing. Police believed hypnosis could bypass the conscious mind and retrieve these memory files from the subconscious.
Like a hard drive.
That was the analogy they used. But psychological research over many years proved conclusively that human memory does not work like a video recorder. You can't just rewind the tape and zoom in.
So what does it do?
Memory is reconstructive. When you recall something, you are essentially rebuilding the event in your mind each time. And hypnosis makes the subject highly suggestible.
So you can plant things.
You can. If the hypnotist asks leading questions, or even just through subtle, unintentional cues, the subject can inadvertently create false memories. This is a phenomenon called confabulation. The subject isn't lying. They honestly come to believe that the new, false details are true and were part of their original memory.
So a witness who might have originally said, I saw a guy who looked a bit like Robert, could, under hypnosis, be led to say, I saw Robert. And once that memory is implanted, you can't get it out.
You can't unscramble that egg. It's impossible to cross-examine a witness effectively on the difference between their original organic memory and the memory that was refreshed through hypnosis.
And this all came to a head in the Supreme Court of Canada.
Yes, with a landmark case called R.V. Trocum in 2007. The court ruled that post-hypnotic testimony is generally inadmissible in court because the risk of contamination is simply too high.
This ruling drops like a bomb right before Baltovich's retrial is supposed to start.
A bombshell. The Crown had built part of their original case on eyewitnesses who had been put under hypnosis. Now, under this new Supreme Court precedent, they couldn't use that testimony.
Their case was crumbling.
It decimated the prosecution's witness list. They were losing their key identification evidence just as the defense was gaining the powerful Paul Bernardo argument. The scales were tipping, and tipping rapidly.
Okay, let's go to 2008. The retrial is set. Jury selection starts on March 31st. Robert Baltovich is bracing himself for another brutal fight for his life. He is 42 years old now.
He spent nearly half his life in this process.
The trial proper is scheduled to begin in Toronto on April 14th. But then, something strange happens. The trial is delayed, and then a few days later, the Crown prosecutor stands up in court and says, well, he says almost nothing.
It was an incredibly abrupt end to a very long story. The Crown formally declined to call any of their planned 50-plus witnesses.
They just folded.
They folded. They stood up and stated that in light of recent developments and the cumulative effect of pretrial evidentiary rulings, which was a direct reference to the hypnosis exclusion, they no longer had a reasonable prospect of conviction.
They realized they couldn't win. They had no case left.
And in our system, if the Crown doesn't believe it has a reasonable prospect of conviction, it has an ethical duty to stop the prosecution.
So with no evidence presented by the Crown,
the judge was legally required to direct the jury to return a verdict of not guilty.
On April 22, 2008, Robert Baltovich is acquitted. He is finally free, not out on bail, not awaiting appeal. Free.
An acquittal is the highest form of clearance in the criminal courts. It restores the presumption of innocence fully and completely. Legally, he was vindicated.
But this is where the story takes another turn, a turn that really requires us to look at the system itself, not just the case. You would think, okay, 18 years of his life lost, A wrongful conviction, a final acquittal. Here is your compensation check from the government.
That's what you would assume.
But that did not happen.
No. In January 2010, the Ontario Attorney General announced that financial compensation for Mr. Baltovich was not appropriate.
Not appropriate. After taking 18 years of his life.
This is a discretionary decision made by the government. There's no automatic right to compensation for a wrongful conviction in Canada. They essentially refused to pay him for the time he lost.
Which forces his hand. He has to sue his own government.
He files a civil lawsuit in April 2010. He sues for malicious prosecution, negligent investigation, and negligent representation, and he names the specific people he believes were responsible.
Who did he name?
The two original prosecutors, John McMahon, who by this time had become a Superior Court judge, and Paul Menta, and the two lead detectives, Brian Raybould and Steve Rezor.
And a civil suit like this has a process called discovery.
Yes, and this is crucial. Discovery is where both sides must put all their cards on the table. They have to hand over all relevant documents, notes, internal memos, and records related to the case. It's often during discovery that information that has been buried for decades finally comes to light, because the standard of disclosure is extremely rigorous.
And in May 2014, deep in the document dump of this civil suit, something incredible was found. A detail that changed the entire understanding of the original 1990 investigation.
Reports emerged from the discovery documents regarding a specific meeting, a meeting that took place on November 2010, 1990.
So let's get the timing right. That's just 3 days after Baltovich was arrested and charged with first-degree murder.
3 days. According to the documents, Detective Sergeant Raybould, the lead investigator on the case, met with two senior forensic experts at the Center of Forensic Sciences in Toronto.
So Baltovich is in a jail cell. The police theory is locked in. He killed her on Tuesday, came back on Friday, and moved the body. 3 days after the arrest, the lead detective goes to the scientists, presumably to check the math on his theory.
And according to the allegations that came out in the civil suit, the scientists gave him an answer he did not want to hear.
What was that answer?
The experts reportedly told Detective Raybould that the forensic evidence found in Elizabeth Bain's car did not support the police's 3-day gap theory.
Wait, they told him it didn't work.
Specifically, they said that the state of the blood and other forensic indicators in the vehicle did not match the timeline of a body being put in that car and moved 3 days post-mortem.
Let's just pause on that for a second. The government's own forensic experts are telling the lead detective, your theory of the crime, the very foundation of your case, doesn't work scientifically.
If the theory of the crime doesn't work, the timeline doesn't work.
And if the timeline doesn't work, the whole case against Baltovich collapses because his alibis for other times become much more relevant.
The implication, as laid out in the civil suit, is that the police theory was known to be flawed and untenable from the very beginning.
But instead of changing the theory or questioning whether they had the right suspect.
The allegation is that they proceeded with the prosecution anyway, presenting that same flawed theory to the jury in 1992 as fact.
And it gets even darker. There's a specific allegation regarding the detective's own notebook.
Police notebooks are sacred documents in our legal system. They are the contemporaneous log of an investigation. You're supposed to write everything down, chronologically, in ink, and never alter it.
And the allegation.
The civil claim alleged that Detective Raybould doctored his notes. Specifically, that he removed the pages that referenced this critical meeting with the forensic experts, the meeting where they debunked his theory, and that he replaced them with rewritten notes from a later date to conceal the fact that the meeting ever happened.
If that allegation is true, we are not talking about a mistake anymore. We're not talking about tunnel vision or unconscious bias. We're talking about a deliberate act to hide exculpatory evidence.
Evidence that points away from the accused's guilt.
We're talking about framing a man for murder by actively suppressing the science that could clear him.
This is the absolute core of the malicious prosecution claim in his lawsuit. Malice, in a legal sense, involves a deliberate intent to subvert the course of justice. If a lead detective knowingly hides evidence that fundamentally undermines his entire case, that is the definition of bad faith.
It suggests that getting a conviction became more important than finding the truth.
That's the allegation.
This revelation in 2014, it casts this long, dark shadow backward over the entire 24-year saga. It suggests that while Robert Baltovich was sitting in prison in the 90s, while he was out on bail fighting for his appeal in the 2000s, there was potentially a notebook sitting in a police file somewhere that contained the proof that the whole case was built on a lie.
It forces us to question the reliability of the entire investigative process in this case. If the forensic timeline was known to be impossible in November 1990, then the narrative that was presented to the jury in 1992 was a fabrication.
The jury convicted him based on a story that the police arguably knew was scientifically invalid from the start.
And that is a catastrophic failure of the justice system.
So where does this leave Robert Baltovich today? He was born on July 17, 1965. He works as a librarian for the government of Ontario. He's built a quiet life for himself, but you just have to look at what was taken.
The biographical gap is profound. From age 24 to age 22, his primary identity was either accused murderer or inmate.
He lost the years where people typically establish their careers, buy homes, start families. He lost his reputation. I mean, even with a full acquittal, the stigma of a murder trial is incredibly difficult to fully erase in the public consciousness.
And we have to circle back to the other person at the heart of this tragedy, Elizabeth Bain.
Yes.
This is the unresolved heartbreak of the case. Because the investigation focused so exclusively and so early on Baltovich, and because that focus was potentially maintained despite contradictory forensic evidence, other avenues were likely neglected or not pursued with the same vigor.
You mean the Paul Bernardo connection?
If Paul Bernardo was involved, and we know for a fact he was active in that area, attacking women at that specific time, the opportunity to identify and catch him earlier might have been missed because investigators were locked onto the wrong man.
And Elizabeth Bain's body has never been found. Her family has never had a funeral. They have never had closure. The theory that the police clung to for years, that her body was moved and dumped in a secondary location, that would have been completely wrong from day one.
If she wasn't moved 3 days later, as the forensics suggested, then whatever happened to her happened differently. She might have been left somewhere else entirely.
The no-body aspect of this case remains the open wound. Without her remains, we can't know the definitive cause of death, and we can't find that final piece of forensic evidence that might point to the real killer, whether that was Bernardo or someone else entirely.
The failure of the investigation didn't just fail Robert Baltovich. It also failed Elizabeth Bain and her family.
It's really a case study in how a system can go wrong at every single level. The police investigation that locked onto a target too early, the alleged suppression of forensic evidence, the use of junk science like hypnosis, the judge's conduct in the courtroom, a parole system that punishes the innocent for maintaining their innocence, and then finally, the resistance of the state to compensate for its own catastrophic mistakes.
It demonstrates that the justice system is, in the end, a human system. It is susceptible to ego, to error, and to the immense institutional pressure to solve a crime, even if the solution doesn't actually fit the facts.
The acquittal in 2008 was a victory for the legal process, for the appeal courts.
Yes, but the decades leading up to it were a profound failure of the investigative process.
Robert Baltovich is a free man. He goes to work, he lives his life. But the questions from that humid June day in 1990 still hang in the air over Scarborough. What really happened to Elizabeth Bain? And how different would everything have been if the police had just listened to their own forensic experts 3 days after the arrest?
Those are questions that, tragically, may never be answered.
Thanks for listening.